We have and we call 25 CR1 806, the state of Texas versus Caleb Baker. And you were Mr. Baker.
Sir, Speaker.
Present with
Yes, Your Honor.
your attorney, Mr. Kimler, and the state's attorney. Does the defendant waive a formal reading of this indictment, the arraignment here involved in this case? Can we proceed in summary?
He does with me, Your Honor.
This is a first degree felony, right, everyone?
That's correct. This is the one with the indictment, the original indictment was in error and had to be re-indicted. We tried to believe before the original indictment.
We're gonna need a pre-sentence report, Ryan.
Yes, sir.
Okay. This is a 6. I'm gonna get that thing on that line.
It says I'm Justin, I know that we do percent report.
Yeah, I'll email them.
Yeah. It's county.
Okay, yeah, and I'll just put it with the, on Sunday, if there's.
Spams.
As you know.
That's cool. Okay, this is guys, they're like, that's on there.
And again, he waives a formal reading of the indictment. We can proceed in summary. And in this indictment, Mr. Baker is alleged that on or about September 25th, 2025, in Jefferson County, Texas, you committed the first degree felony of aggravated assault by discharging a firearm at or in the direction of a vehicle.
It was from a vehicle to another vehicle.
Mhm.
Yes, sir.
And do you understand what you're charged with here, sir?
Yes, sir.
If convicted of this, which is a first degree felony, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable here?
Yes, Your Honor.
An agreement has been reached with you, your attorney, and the state that whatever sentence shall not exceed a cap of 6 years in prison. So let's work this out.
Yes, sir.
You can be sentenced to no less than 5 nor more than 6 years in prison. You could be placed on deferred or unadjudicated probation, which can be up to 10 years in length.
Yes, sir.
I don't think regular probation is an option because a deadly weapon, namely a firearm, was used in the commission of this offense. I believe those are your options. Is that your understanding of the plan?
Yes, sir.
And what we would do, you would enter your plea, and then we will order a pre-sentence report, come back in a few weeks. Everybody gets to add additional information they want me to consider, and then the court, they make arguments and the court will make its decision. You understand?
Yes, sir.
All right, that's our plan. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes,
I'm
sir.
going to show you what's marked as State's Exhibit 1 there. Did you sign that document? Discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence
Without objection.
without objection admitted. State's Exhibit 1 states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and you're adding lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God.
Yes, sir.
State's Exhibit 1, part of the record without objection. We will order a pre-sentence report. We will return back on January 26th next year. And again, additional information can be presented by the parties and I will make the decision.
Yes, sir.
Did the court consider bond reduction pending sentencing?
Not at this time. How long have you been in jail?
Since September the 30th.
Because it's an aggravated offense, the court is always reluctant to do that. I seldom I can't remember when I've done it, but I may have over the thousands of cases. But it's not normal for this court to do this until such time I see the pre-sentence report. And actually, it's not necessarily your sin, but the sins of others. We've had others flee when they were looking at, now, I must say, they didn't have a cap. They were looking at like the full amount, like up to life, and they took off. And it took a while, and we did that. That was more than once, but I quit doing that because people think that maybe it's best they take off, and then it just holds it in limbo. And it's a bad example for others because they'll say, hey, Fred got it. I ought to get it too. And I go, well, Fred ruined it for everybody. But you'll get credit for all time. You're going to serve. Cases like this, even when I put people on probation, I generally have on an aggravated case, I can put as a condition of probation up to 6 months in the county jail as a condition of probation. But we'll see what happens with this. But you'll get credit for all time you've served. Okay, you're in recess on that, and we are getting ready for the cat. Where's my trial?
Judge, we do have officers available tomorrow, but our lab person.
Yeah. Four cases? Or five? Five. All right. Mr. Curtis, as you know, you're charged with serious offenses involving child pornography. There's a first degree felony, which carries with it up to life imprisonment in 2459. Then there's a state jail felony, invasive visual recording in 460, which carries with it up to 2 years in the state jail. Then we have another state jail felony of invasive visual recording in 461. And an additional illegal possession of promotion of lewd visual material depicting children, a state jail felony in 2462, and finally in 2463, a second degree felony of burglary of a habitation. So that carries with it up to 20 years in prison. So it's total, you're exposed to 26 years in prison plus life on all of these, adding them up together. All right, what are we going to do?
Judge, I know we're getting up there in age a little bit.
Yeah,
Miss
yeah,
Moore
year
recently
yesterday, I think.
inherited these cases upon her return to the VA's office. Mr. Davis and I would like some time to speak with her before we formally put these on the file docket.
You got 4 weeks, and that's it, right?
Yes, sir.
Probably.
And okay, and we're going to go to trial. You know, it's going to be the 2459, the first degree felony.
We know that. That's why
We'll take that
I'm
first.
asking before we get that.
All right, and we'll go one after another. Get a resetting.
Thank you.
Okay. Awa,
He's present.
or 557. That's another old one. This is another old one.
I know.
So
Here, sorry.
today,
Yes, sir.
what are we gonna do?
I suppose the court could put it on the trial docket if that's necessary. I've got an issue in another county that's unrelated to this. Frankly, doesn't have much bearing on the outcome of this case at all. But
I think there's a deferred offer written down. I don't know what the status of that is, but it's not going to change right now. If you want to just have a little time to work on the other county for a minute. That way we don't have to place it on the trial docket. Just give them 2 weeks.
This case will get resolved without a trial this month. I need the other county's issue to have an answer before.
Time wise, what do you ask?
6 weeks.
How much?
6 weeks.
I'm gonna do you 4.
Okay.
Okay, thanks. Armando Alvera, is that a hearing?
Here, sir.
That's a hearing.
What about Andrew Barnett?
He's present, yeah.
It's all right there in the edge.
So,
Yeah, you're gonna have to unless you want to.
I don't.
I don't.
Right there. Yeah,
Trial
sorry.
docket petition.
okay.
We were waiting for me to find the complaint. I found him in Louisiana, and he's wanting this prosecuted fully. So it's
Okay. 3rd-degree felony up to 10 years in prison.
Yes, sir.
right?
Yes, Judge.
I'll give a lot of these.
yes, sir.
This,
We tried a bunch of them.
sir.
We've tried several of them.
Okay. Then it will be set for trial. And then Alvera.
This one we already tried jury gave him probation. I think he's asking for removal of something that was on the bond, but it's not on his probation order.
I filed. There's a misdemeanor DWI that was the companion case to the case that we tried in early October.
This is the case out of
Yeah.
command.
Yes.
After we received probation from the jury.
Yes, Judge. After that happened, 2 or 3 weeks later, we resolved the misdemeanor DWI for time in the county jail. My belief is that once that judgment was entered, the bond conditions on the misdemeanor are extinguished. So as a condition of his bond on the misdemeanor DWI and at the interlock, he's had it in his truck for 4 years. My position is that the judgment is what should be sufficient to take to Smart Start or any other interlock company to say, I now could have this removed. He's not on probation. It's not a condition of his probation.
Why can't I add it as a condition of probation?
You can, I suppose, as a condition of the felony probation. I obviously would ask the court not to. He's had it for.
Well, okay. What are we talking about now? What we're talking about, auto ignition interlock?
Yes. It was a condition of bond in the misdemeanor case.
Okay.
I filed a motion in county court to have it removed because Smart Start?
Yes.
Smart Start has found insufficient the judgment to take the interlock out of his truck. He is perfectly within the rules to have that removed. It's no longer a condition of his bond. He's not on bond.
Judge, I don't know if we have anything in this court to do with that on the misdemeanor DWI. That may be between the judge there.
Okay. He does.
It declined.
I've got an order in August signed ordering him to have an auto ignition interlock system as a condition of community supervision in this case.
On what date, Judge?
August 27th. Which would be normally customary in something like this. I normally do that. And that was in August. He hadn't been doing that?
He has been.
Yes.
Oh, okay.
They're trying to get it removed.
The interlock has been in his truck since December 20
Okay.
something of 2021.
Okay. For a different reason.
As a condition
the
of
auto
bond.
ignition interlock is here for this reason, because it's a condition of probation from the jury decision.
Which I overlooked this, otherwise I would have addressed it
Yeah,
differently.
All right, but I signed, I can't remember actually doing that, but that would be normal and customary. That's what I do in this type of offense.
Wouldn't it be, Your Honor, more normal and customary in a case that's actually a DWI indictment and not? I know this was an alcohol related case. I'm not pretending it wasn't. That's why we tried it. But it was an accident involving injury, not DWI.
It doesn't matter. It was part of the circumstances of the cause of the event.
Understand. Our position, I won't re-argue the bond thing. He's had it for 4 years. He's done well. I know the court and the state's position is probably, yeah, he's been in there for 4 years. I get that. But at some point, there must be some level of relief now that the case has been resolved. And I think that the jury's verdict, based on everything that they heard, carries some weight.
Of what? Of what as far as this condition is concerned? Why does it carry weight for my decision on a condition of probation, which involved a circumstance involving alcohol?
I think if the jury
That's what
believed that those two things were that related, we wouldn't be here. He would have gotten 10 years in prison.
I'm sorry. Well, number one, you bring some jurors up here and testify to that, number one. But number two, when it becomes my supervision, it's my domain, not theirs. But I don't remember them saying that or reflecting that. I remember this situation. But this, whenever there's an involvement of alcohol or drugs, then we do something to prevent someone from doing something a second time involving a 4,000-pound missile. Everybody has to act responsibly. Lives are dependent upon it. So I'm going to stand by right now that order, and it's going to stay that way. And what does it cost you?
Like $200 a month.
I'm sorry, sir.
$200 a month.
Where are you employed? How are you employed?
I'm self-employed.
Okay. And at the end of the day, this is what I'm going to conclude with, because I think this is what carries the day on this issue. Mr. Alvera, the consequences of this condition to you and the difficulty that you have to deal with it, and it's the inconvenience of it and the cost of it is far less than the family that lost their loved one forever because you fled while they died at the scene. That's what I balance. Can you understand?
Yes, sir.
It's not a close call. You can figure out how to bring them back to life. I'll drop this condition. I'll probably relieve you of this condition sooner than later. But right now, it hadn't been but a few months.
I don't mean to be argumentative, Judge, but
what was my order? I'm talking about my order on this.
I understand.
Okay.
I want to be clear that he had it in his truck while the case.
I'm just talking about my order
Understood.
on this probation. Yeah. Okay, what else?
The misdemeanor case was resolved. The court will also recall that it ordered upfront jail time after the jury's verdict.
Was it
Armando,
180 days, I guess? That's what. Stand
I
by.
think it was 180.
Oh,
It was all of it.
Hold on. And here's the judgment on this. What's the 180 days jail time on that?
It's gonna be in a separate. It'll be,
yeah, copy this. It's not on there, Judge. That's just the interlock. That's yours. That came out of the court's file.
Oh, okay.
That's all I want to make sure it got back for.
Thank you.
that was assessed at sentencing?
Yes.
Have you been going
Yes,
to
sir.
jail?
Yes, sir.
I know I remember orally ordering that. I'm not seeing it on the written order. Which is
The court
more of a
oral-
it's a memorialization,
Right.
but the court made its order, but it's not in the written order.
But if it's dictated, the dictated order.
Yeah, I mean, I made it.
I know the court told him to go because I told him to go, and I wouldn't.
Yeah, I know.
volunteered
I
to
made
do otherwise.
I made the statement and it was an order. It was an oral order, but we normally memorialize those for posterity.
Yeah, I'm
It-
looking, Judge, I have the order where it shows that he could start weekends.
I think we waited a couple weeks after the verdict to get some affairs in order.
Yeah, I have the order where it said he could start weekend jail time.
Nonetheless, it was ordered. Sure. And it's somewhere in the 5,000 case load paperwork that we're having to deal with in this court.
Overstood.
So go ahead. What do you?
I'm asking the court to suspend the remainder of that time. He's done it faithfully.
How many days has he been credited with? Do you know?
He's done.
It's done the 19th.
You're doing every weekend?
Yes, sir.
How many days are you getting credit? Is it 3?
My
You come
PR.
in on Friday
Yes, sir.
and then they release you on Sunday?
Yes, sir.
You should be getting 3.
He's done.
I thought each day, I thought when he shows up, they give him that credit for that day, and then the second day, and then the third day, even if it's partial, he gets 3 days.
That's correct.
That's, they stopped it. They only give them 2 now.
Did you know?
They
Kendall?
give them 2.
Yeah, they did stop it, Judge.
Oh, they're just giving it per hour. You have to have 24 hours.
Yes, they're only doing 2 days now, give them 2 days credit.
All right.
Which
I don't know how much. Well, do we know how to credit his jail time? We can do that. We can find out where the number is.
Yeah.
Did we find something?
It might be, I reprinted the file, Judge, but I didn't have time to go pull it from the vault. So it might be in an order that's not scanned in our file that's in the vault. I just, by the time we got out of court yesterday, I didn't have time to go pull it, so.
Because I've got the community supervision order. I've got
So I reprinted everything that was
the
scanned.
supplemental order signed on the same day
Mhm.
of additional terms of probation, which is
It just may be in an order that's not.
auto
stated.
ignition, complete MRT, moral reclamation therapy, and complete defensive driving as directed. But there's no, but I know I orally ordered there it is, serve a term of 180 days in the county jail. It's in this order,
Okay.
over the top.
Okay.
But if you can tell me how much credit, and I will say this, this isn't the timing of such a thing, such a request is not ripe for me at the Christmas holiday season. I'm not gonna stop that condition, since this is the most vulnerable time for people on the roadway. This is where most deaths occur during the holiday season. And
Has he been doing weekends, Paul?
Yes.
Because it.
so I can revisit this at another time, but not now. I'm not going to grant it right now.
They're not showing it?
Well, it doesn't show that he ever booked out.
He's right here.
I know. But that's what I'm saying. I'll have to call and tell him.
Following him for the skate?
Yeah.
See, that's how they do it now. They don't do it, they don't book them out until actually the last day. But if you look at the screen that shows the something screen, it'll show like the exact days.
Well, does it have a running total? That's what we're looking for. Where's the data that shows a running total?
Well,
What's
What?
his time?
You're showing it's still totaling today, too.
Yeah.
Section.
One more issue, Judge, from the court.
Which question?
Because when I go to jailings, it's 91, which is not accurate.
These phones, you turn. But they have broken up in increments.
Okay, so
Is it at the top?
It should be at the very top.
he started in August.
Are you gonna hear?
Yes. Or September.
I mean-
Right, because August was the judgment.
Same thing we. Sure.
Yeah. What's it called?
See, this would all been afforded that you're not.
September, October, November.
Got what I asked for, more issues.
See, my one is so simple.
I don't think I have
Done it.
permissions for that.
Okay. So the thing.
That would have been, so I still have this stuff.
I mean, he can't have 30 to 40 days if he's only doing 2 days.
That's
Spring.
okay.
He's only credit to 2 days.
I know.
He's only got 30 or 40 days credit.
Yeah, I don't have permissions for whatever screen breaks it down, Judge. I'll have to see if I get permissions for that. So I don't have an accurate.
But during this time, at this time for the circumstances of this case, I'm not granting the relief right now.
Would the court consider modifying his weekend curfew or his ability to operate a motor vehicle on the weekend in lieu of fully suspending jail time? It's about to be crawfish season. He's about to move to working 8 days a week. And the weekend time
Okay,
is valuable.
what is the,
What?
okay, I have
So that's
be inside your home 10 p.m. to 6 a.m. That's the only curfew.
I'm sorry.
It says be inside your home every day, 10 p.m. to 6 a.m. That's the only curfew. What else is there? What do you, I don't see anything.
The way to get some relief. That's
Well,
all of it.
what are you asking for? Because I'm not keeping him in home except during for curfew. I mean, he can
And with
out and about as long as he has an auto ignition.
And with curfew, usually they'll allow you to work if you're working. Isn't it true? Probation allow you to work if you've got a curfew, if you work past that curfew, as long as you let them know.
The reason that I'm asking is because the weekend jail time is going to affect his ability to work. That's why I'm asking for the
Oh,
relief.
okay, but I'm sorry, but he's going to continue to do weekend jail time for the reasons I stated. It was a fatality and a death. And that may infringe upon his work opportunities, but it's pale in comparison to what happened here and the loss of life. What's the value of that? There is no value to it. It has no quantifiable because it's forever. And the loss of life is the most precious thing that we have.
Okay.
When we lose it,
Yeah.
there isn't anything that is close to value that compares to it. You have your life. You've got some conditions which may be difficult or inconvenient, but you've got a life to share and enjoy with your family and friends. This deceased person doesn't, and their family was lost. And at this time of the year, I'm sure they think, well, that's what people think about. It's their loved ones here and gone. So no, I'm not going to grant the relief at this time for this situation.
We can certainly reserve our right to revisit it later.
Yep.
Jen. Okay.
Okay, you may. Yes, sir. All right. Who else was this?
Excuse me.
Is that it?
Yes.
Okay, that is Andrew Barnett,